In sports-related news, the NCAA, which represents student athletes at colleges, has filed an additional lawsuit that aims to help classify the student athletes as employees for the purposes of federal labor law. This has been a long contested issue when it comes to sports and colleges. Colleges, of course, created sports initially as a pure intramural thing, just an activity that people can do just for fun because people like, to play sports. And so sports basically started as just a student organization. And then, of course, students wanted to play students at other schools in sort of a way. And then it became more formalized and more formalized and more formalized until you get to the place where the student athletes are bringing in huge amounts of money and are not getting any benefit from it other than, free tuition and room and board and things, which isn't nothing, but isn't exactly the money that they'd be getting if they were playing for professional sports. So one of the issues is, how do we deal with this? There was a recent change, of course, that said that student athletes do have rights to their own likeness after college. So when it comes to video games, and for example, they can at least market on that. But how about while they're students? Are they employees? Do they get any federal labor or other benefit protections? So we are now trying to sue in relation to that. Let's learn a little bit more about how we're trying to change who is and who is not an employee for the purpose of federal law. Let's get started in this. The National Labor Relations Board is hearing a case dealing with student athletes that seek to change their status as employees. And this precedent could also help other people beyond college athletes, depending on the nature of it, because it could also stretch into gig economy drivers and other workers who are currently misclassified as independent contractors. So this issue as to who is an employee and who is a contractor is obviously very complex. And there is a lot of different tests on this, depending on which agency is resolving this issue, and also a matter of state law as well. The entire case about who is and who is not an employee often boils down into a multi-factor test, and sometimes it's like a 13-factor test because it's really complicated as to who an employee is and who not. Among other factors that might indicate if a person is an employee or an independent contractor would be factors such as, is a person able to set their own hours? Do they use their own tools or do they use the employer's tools? Where's their place of work? Do they work at the employer's place or do they work wherever they want? Are they able to work for other companies? Are they able to set their own conditions of employment? Are they able to set rules for themselves? So these are some of the many, many factors that apply to this. And obviously, how college athletes and how independent drivers for such things as Uber work into this is obviously a much contested issue, as you would expect. The recent complaint against the National College Athletic Association, Pac-12 Conference, and the University of Southern California claims that they employ football and basketball players who are illegally misclassified as non-employee student athletes. So we are trying to say that these student athletes are actually employees rather than students. If they won the case, it would require NLRB to rule the act that misclassifies the workers violates the National Labor Relations Act, a legal theory that, of course, has been rejected in the past as well, but an issue of increasing interest in this domain. The case sets up a chance for two precedential holdings, one relating to college athletes, the other for misclassification being a per se violation of the National Labor Relations Act that appear in a single case, which is a rare occurrence. So this would potentially not only solve the immediate issue, but also say that misclassification is in and of itself a violation of law. So it would allow people to more easily change their classification status because it would be an unfair labor practice as a matter of law, which it isn't right now. Right now, it's just like, which category are you in? But this would potentially change to say that the act of misclassifying is in and of itself a act of aggression on law. Only in a previous incident in 1969 with the United States Supreme Court, there affirmed the board power to order an employer to recognize and bargain with a union in absence of an election when labor law violations make a fair vote impossible. So again, dealing with this issue, federal law does protect union and union rights. One of the things that might prohibit a union from forming is the employer acting in a way that inhibits the union from forming. And so there is precedent for the idea that you can force an employer to recognize a union even if there was no vote, to create the union if the employer itself is prohibiting the vote from occurring. So there is some precedent on that issue as well. While the rule is known for allowing these orders, it also set an important precedent on the distinction between a lawful prediction and an unlawful coercive threat. So yeah, this gets really, really complicated, really, really fast, as you would expect. Employers do have free speech rights, including the free speech rights to say we oppose unions. So merely the employer saying we don't like unions, unions are bad, here's all the reasons you shouldn't vote for a union, that in and of itself is not illegal. It's only illegal if it becomes coercive. And God knows that a lot of employers try to tread that line real close. So in terms of where they are and stuff, it can get really, really complicated. But employers are pretty good about towing this line. Perhaps too good, but that's where the law is, right? So there's a difference between merely saying, we don't like unions and we'll fire you if you join a union or create a union. So how employers play that line is obviously really interesting. The misclassification complaint against the NCAA is not the only major pending case on this issue, as you would expect. There's lots of issues that are related to this. The General Counsel's office is also litigating a case relating to a construction company that argues for resurrection of a legal doctrine allowing unions to represent workers without an election, as well as having compulsory anti-union gatherings declared illegal. So one of the things that employers can currently do is gather everyone in a room and be like, geez, aren't unions bad? We don't like unions. They're really bad. We don't like unions. Unions are a bad thing, and you should not like unions. And we don't like unions, and we hope that you will not recognize the wisdom that unions are bad. And they're allowed to do that. So this is a very fine line between, we don't like unions and nice employment you have here would be a shame if anything happened to it. So that line between legal expression and blackmail, well, some employers are towing that line really, really closely. There had been a case that challenged a decision and argued for making misclassification a standalone labor violation. But that particular case, which stemmed from union charges relating to trucking, settled before the ALJ could do it. So again, is misclassification itself a standalone violation? Not right now, but someone is trying to change that, but a prior precedent settled before the issue was resolved. The joint case against the NCAA, Pac-12, and the University of Southern California will probably take a long time. Yeah, that's for sure. The closest comparison is arguably the joint employer case litigated McDonald's. The case began in 2014, didn't end until 2022, when federal employee court rejected a union challenge to settlement agreement that cleared the company of any joint liability. So yeah, these things can take a long time because they're factually complex, they're legally complex, and the line is a little bit blurry, and God knows employers play with it. Thus, that brings us to the end of the case dealing with reclassification efforts as it relates to the NCAA, which could potentially impact gig economy businesses and other businesses, depending on the nature of the ruling. So we're going about this two different ways. First, we're saying that we have been misclassified, and they are employees, which is an issue unto itself. But the bigger issue is that misclassification is not, as of now, a violation of labor law unto itself. So it might be wrong, it might be the wrong status, but the fact that we misclassified you is not in of itself a labor violation. So the only remedy is to change your status, right? Say, oh, you really are independent contractors, or you really are employees, as the case may be. But there's no penalty for getting it wrong, which obviously might incentivize some businesses to, get it wrong because there's no penalty, and they gain the benefit of the benefits of the status while it's in play. So we're trying to change their status, which is an issue unto itself, and also trying to change it into a fundamental per se violation. So that would be a penalty for misclassification. So this issue will be long percolating, I am sure. I don't know how this will resolve in the case of the NCAA, to be honest. I don't know that will ultimately get anywhere on that particular issue. because the nature of what we're talking about, but they're going to try. And that, for the moment, brings us to the end of discussion of this case.